I think we're having an awakening going on, if I may suggest that, among lawyers, among people who are understanding, wait, the pie is not what we should be looking at. We should be looking at how we can expand, because when we expand to deliver legal services to those in need of all types, we are going to create opportunities for lawyers. And that resonated in our report as a message, and I think it is now being heard. Change will benefit lawyers in the long run.
Today on LawNext, a deep dive into what may be the most critical issue facing the legal profession: legal regulatory reform. With a panel of 5 of the leading thinkers and doers who are at the forefront of the profession's re-examination of how we regulate the delivery of legal services. The occasion of our coming together here is the just-released special issue of GPSolo, the magazine of the solo, small firm, and general practice division of the American Bar Association. This special issue is devoted to exploring the various facets of regulatory reform, with a roster of a dozen writers who have all been immersed in re-regulation, each in their own way. The 5 guests joining me today were all contributors to this issue of GPSolo, and one, Patrick Pallas, was the issue editor who pulled it all together. Today we'll hear their insights and perspectives in the hope that listeners will come away with a better understanding of just why this issue is so critical. This is Bob Ambrogi, and you're listening to LawNext, the podcast that features the innovators and entrepreneurs who are driving what's next in law. Before we get to today's guests, let me tell you about the sponsors who so generously support this podcast. Paradigm is changing the legal landscape. With their practice management solutions Practice Panther, Bill for Time, and Mariscase, and the online payment solution HeadNote, legal professionals can easily manage their practice anytime, anywhere. More than 40,000 lawyers trust Paradigm to automate and grow their practice. Learn more at joinparadigm.com. Now, on to our conversation. And given that we have so many panelists on this program today, rather than introduce you all, I'm going to welcome you all, but ask each of you to introduce yourselves so that we can associate your voice with your name. So, Patrick, let's kick it off with you. Tell us who you are and what you do.
Thank you, Bob, and thank you for the invitation to join you today. I'm Patrick Pallas. I'm the former bar president of the Washington State Bar. I'm a member of the ABA Center for Innovation Board and have served, and I'm now just off the board for the National Conference of Bar Presidents. And maybe importantly to this topic, I'm a small practitioner. I have a small firm in Tacoma, Washington.
Thanks, Patrick. And Judy Perry-Martinez, a return visitor to this show. Happy to have you back again.
Thank you, Bob. I'm delighted to be with all of you. My name is Judy Perry-Martinez. I'm from New Orleans, Louisiana. I just finished up my term as immediate past president of the American Bar Association. And pertinent to this great conversation, I also served as the chair of the ABA Presidential Commission on the Future of Legal Services.
Thank you, Judy. And another return visitor to the show, Justice Timmer.
Good morning, and thank you so much, Bob, for the repeat invitation to join you all. I currently serve as the Vice Chief Justice on the Arizona Supreme Court, and pertinent here, I chaired the task force which made the recommendations which ended up with our regulatory reforms.
Thank you. And someone who has not been on the show before, Zach DiMiola. Zach?
Thank you, Bob. It's an honor to be here with such good company. My name is Zach DiMiola. I am the Director of Legal Education and the Legal Profession at ILES, which is the Institute for the Advancement of the American Legal System. And for those that don't know, ILES is an independent national research center at the University of Denver, and we are devoted to the continual improvement on the civil justice system. Re-regulation is a big part of what we're doing. I should also say I'm a former attorney and also on the board of the ABA Center for Innovation too.
Recovering attorney, isn't that the phrase we use? You're recovering.
That's correct.
You never quite get it out of your system. And last but not least, Joseph Gartner.
Hi. Thank you so much for having me here today. My name is Joey Gartner. I am the Director and Counsel of the ABA Center for Innovation. And at the Center for Innovation, we support and foster an environment that encourages innovation in the legal profession.
Well, thanks to all of you for coming together here today, and I hope we have a good conversation. But Patrick, since you were the issue editor here, I wanted to start with you and just ask the question of why did GPSolo want to tackle this issue in this much depth?
It's a great question. I think an important one, because I think as we all recognize, there has not been an ABA publication dedicated to this topic of legal innovation and re-regulation. And there's so much going on across the country. And GPSolo is the widest read magazine for solo and small practitioners that make up about 2/3 of the lawyers across the country. So what better place to have this discussion than truly with all of the hardworking lawyers across this country who have the biggest stake and need to know what this trend is and what's happening and how it works and what it means to them and how it's important for them. And so for me, that was the call to come to my board and say, I think we should explore an entire magazine. We'll get the best people in the country. We'll write about this from every viewpoint we can find. And we're going to do a thorough deep dive into what legal innovation and re-regulation could look like for this country and how it'll affect and how it could change and how it can improve access to justice and better us as solo and small practitioners. And so we did. It took a little bit of work. It took some time getting everybody together and the articles decided, but here we are. It was published on Monday and it's a big deal. And I'm very proud of this magazine having come together and really lucky to have the laundry list of scholars and experts that we did put together to bring this magazine.
It's a great issue. I've binged on it over the last couple of days. But let me just push back a little bit on what you just said, because in terms of presenting every perspective on this issue, you really didn't present the counterpoint. I mean, most of the people, I think all of the people who contributed to the issue are in one way or another, I think, advocates of reform or re-regulation. Why did you choose to present it this way?
We looked for authors from all sides. In fact, we approached, I'm on the editorial board, we approached GPSolo and said, open this up to everybody who wants to write. And if somebody out there who has a strong opinion against all of this, well, let them bring it. And the truth of the matter is that there are a lot of views. We have views from ABA leadership. We have views from the center. We have views from Supreme Court. We have from legal ethicists, professors. So we do have all the views in here that look at this from all the angles and pros and cons that I think are important for someone to make a decision about whether this is the best route forward.
Fair enough. Judy, I wonder if I could turn to you, because as you mentioned, before you were ABA president, you were chair of the ABA Presidential Commission on the Future of Legal Services, which in 2016 released a report on the future of legal services, really a groundbreaking report that I think it's probably fair to say that report really has played a significant role in getting us to where we are today, sitting here talking about this. It was certainly influential, and I think it was certainly key in defining the scope of the problem and the need for changes in how we deliver legal services. And in your foreword to that report, you called for bold action and innovation in order to achieve universal access to meaningful assistance for essential legal needs within our collective reach. I wonder if you could just kind of sketch out a little bit what would briefly, given the time we have here, but what was the problem? What was the issue that the commission found that urged it to make this call for bold action?
Bob, I think importantly, what we realized is that we needed to say some things that everyone recognized, but many had not acknowledged. And it was important for the commission of the American Bar Association to do so, that the access to justice problem was real, that we were not able and had not been able to address it, that we had to think more through the lens of the consumers of justice, both individuals who did not have access because of perhaps their inability to pay for legal needs, but also to make legal needs more accessible and affordable and efficient and better for all types of consumers of legal services, the largest of corporations and the smallest of businesses. And so that really was what framed up the commission's report in 2016, stating exactly what those legal needs are and the enormity of the challenge that our nation has faced for decades, but we have not met. And as a consequence, and I say that I mean individually as well as collectively, with the best of mind to the table. And so what the commission's call to action was about was to looking across disciplines, to bringing in the best and the brightest within and outside the profession, to see how we could challenge the profession to have the very types of conversations that you have brought us here for today, and that this special edition of GPSolo, we hope, will just spur across the country in towns and cities of all sizes, in law firms, in law departments of all types, and most particularly in the very rich and important community of solo practitioners and small firms across this country.
I think something that's interesting about this issue of GPSolo and about some of the contributors to this issue is exactly the fact that Patrick made before and that you're making now, which is that it's, the American Bar Association is behind this. We have Supreme Court justices talking about this here, ABA bar presidents, state bar presidents. Another reference back to that report, because in that report, you laid some of the blame on the legal profession itself, saying the legal profession continues to resist change, not only to the public's detriment, but also to its own. So do you think that has changed in the 5 years since you issued that report? Is the legal profession less resistant, more accepting of this change?
I think it is. And with my ear to the ground on a pretty persistent basis on this subject across the country, and watching the great work that's going on by people like you have gathered today, but as well as the many others who contributed and are contributing to the dialogue, that has to happen. I think what we're seeing is a growing awareness of not only the benefit to the public, which should be first and foremost with regard to any changes that are put in place. And those changes don't have to be dictated to any particular state. It's what that state and their Supreme Court and their bar and the people, the stakeholders think is best. But also, I think we're having an awakening going on, if I may suggest that, among lawyers, among people who are understanding, wait, the pie is not what we should be looking at. We should be looking at how we can expand, because when we expand to deliver legal services to those in need of all types, we are going to create opportunities for lawyers. And that resonated in our report as a message. And I think it is now being heard and needs the good leaders that we have here today to help people understand that change will benefit lawyers in the long run.
Justice Timmer, if I could turn to you for a moment, no state has gone farther down this road of re-regulation than Arizona, and you chaired the Arizona Supreme Court's task force on the delivery of legal services, whose recommendations led to the changes that have been implemented in Arizona. And of course, as Vice Chief Justice, you voted to implement them. We could spend an entire episode talking about what's happening in Arizona. And in fact, we did when you were on the show before. But in the article that you published in this magazine, which was titled Regulatory Reform, What's in It for Me, you talk about kind of the two main changes that Arizona implemented. And you talk about how solo and small firms can potentially benefit from those changes. And I think that's really an important perspective that's not often talked about. I wonder if I could ask you to kind of maybe, again, in nutshell fashion, kind of talk about the two main changes that you implemented in Arizona and what that means for solo and small firm lawyers.
Well, certainly. First, it's extraordinarily important to me personally that the small firm lawyers and the solos thrive, because they are really the backbone of the legal profession, the part of it that is providing services to ordinary people out there. The larger firms, they're really going after corporations, companies, entities, that kind of a thing. So it's vitally important to continuing to deliver access to justice to everyone, or as many people as possible, that we have a thriving small and solo practice in the U.S. So it's certainly to all of our benefits to make sure that lawyers that are practicing in that environment thrive. And that's part of the reason why I wanted to write the article saying, what's in it for you? Because I don't think that opening things up and making these changes is mutually exclusive to the idea that those lawyers will thrive. And I think that's what we need to drive home. So in Arizona, the two major things that we did is we have authorized a new tier of legal practitioner who is authorized to practice law. In Arizona, we already had document preparers for the last 15 or so years and had success with that. So we already have about 600 to 700 people that the court certifies to help people fill out forms, but they can't give legal advice. Now we have something called legal paraprofessionals that are allowed to practice in 4 distinct subject areas. So family law is probably the one where you do see lawyers. The other 3, you don't see lawyers too often. It's limited jurisdiction, so city courts and such, misdemeanors where there can't jail time involved, limited jurisdiction, civil matters, so low dollar amount matters, and administrative agencies which allow folks to come in. So that's the area. The other one is ABS, which is alternative business structure, allowing lawyers to partner with non-lawyers and share legal fees. So we eliminated ER 5.4, which is what says that lawyers and non-lawyers can't share fees. And now you can partner and expand your services. So what's in it for lawyers, small and solos? Well, lots of things. Now you can innovate and reimagine your practice. So with the limited or the legal paraprofessionals, perhaps you do family law. Now you can employ people and take on a greater quantity of cases and expand your practice and send those folks into court on some of the matters that really don't warrant a lawyer, but people still need advice and still need help. So you can expand your practice there. You can partner if you're. We've had one ABS that we've licensed so far that I know is an estate planning firm. So they've partnered with some financial planners. And so they can expand their services there rather than just do what they had been doing, which is just referring work to each other back and forth. Now they're a one-stop shop for that type of thing. So there's a lot that can be done with lifting ER 5.4 and allowing for alternative business structures to exist.
Zach, 5.4, as Justice Timmer just talked about, has probably been the most controversial aspect of the discussion around regulatory reform. I keep calling it reform. Others might not call it reform. I like that the magazine referred to it as re-regulation. I think that's a good way to put it. But your article honed right in on that point. There is this fear or this belief, anyway, among a lot of lawyers that 5.4 is essential to protecting their ability to operate and exercise independent judgment as legal professionals. You take issue with that. I mean, talk a little bit about your article and the position that you take on this.
Yeah, thank you, Bob. I mean, I think the fear is understandable. I mean, it is essential that a lawyer have independent judgment, right, to serve the public. But does that mean that 5.4 is essential? And my article essentially says no. 5.4 has a lot of problems with it, and in fact, some of the problems were noticed in the Arizona Task Force's report and recommendations that there were really no evidence that supported 5.4 when it was created, and there's no evidence suggesting that we need categorical prohibitions on lawyers' ability to enter into different business models or share fees under certain circumstances or offer equity to people who aren't lawyers. And the great fear that our independent judgment will collapse if we actually delve into these types of things is sort of belied by the evidence elsewhere, where we've seen lawyers in other common law countries participate in these sorts of things, and the sky hasn't fallen. And in fact, what the data shows is quite the opposite, right? Instead of these other professionals dragging lawyers into an ethical mire, what ends up happening is the ethical standards of the lawyers raises the standards of the professionals around them. I think there's this assumption that, back to the idea of re-regulation, right? There's this assumption that if we get rid of Rule 5.4, what we're doing is deregulating. That's not entirely true. There are other ways to ensure that the independent judgment of lawyers are protected, even in these other sorts of circumstances or business models. We've seen that in Australia, we've seen that in England, and we're seeing it in Arizona now. We are quite capable of ensuring that our ethical standards remain in place, even without the sort of categorical prohibitions that 5.4 has now.
Yeah. Justice Timmer, just to jump back to you for a moment, your task force found with regard to 5.4, quote, that the prohibition was not rooted in protecting the public, but in economic protectionism. Pretty harsh words.
Well, that's right. And we weren't the ones to coin it. That came from the academicians that looked at it and really looked towards the origins. And if I recall, it was the banking industry that was scaring the lawyers then, that banks were hiring lawyers and didn't want banks competing with law firms in providing legal services. So that was the origins of it. But as Zach said, it's become Through the years, though, I think people have gotten away from those notions and think of it in terms as protecting lawyer independence, conflicts of interest, confidentiality of client information. But we have other ethical rules that cover that. So it really has become unnecessary in our view.
Yeah. Joey, waiting patiently as we've gone through all these panelists. I appreciate that. One of the perhaps tangible and lasting outcomes of the task force that Judy led in the report that they issued was the establishment of the ABA Center for Innovation. Joey, can you talk a little bit about what is the work of the center and how is it contributing to the conversation around regulatory reform?
Sure. Well, we were a direct result of that report. We were launched in 2016 as the findings indicated this was something the ABA needed to be involved in. Our mission is really threefold, right? It's to educate and engage in a conversation. It's to provide research-based projects that help outline what's going on in the regulatory space and the innovation space. And it's to provide some real-world application for those projects. Two of the key focal points that we have right now, first are our legal regulatory survey, which is a point-and-click map. You can see what's going on in any state. You can see where that state compares with the model rules, where it differs, where it varies. And we also continue to maintain and update that. So the recent reports in Florida, in Washington, that are reflecting interest in additional sandbox, that's something that we want to make sure that is available for people to see, is available for the profession to understand, and is available in a clear, straightforward way that is accessible. The second companion piece to that is something we'll be launching later in the fall, and that is a data metric project where we're trying to compile comprehensive indices of what should regulators be looking for? What should anyone approaching the legal space be evaluating and measuring? Because key to this sort of re-regulation is going to be, does it work, right? How do we measure that success? And we can't do that without data. So the center plans on launching these indices in the fall that are going to be designed to really bridge that gap and allow regulators to see the relationship between outcomes, between measures, between data sources, and really start thinking about data as being a key and integral component of where we're going as a profession.
Yeah, go ahead.
I'm sorry, Bob. This is Zach. I just wanted to chime in on that because I've been working with Patrick and Joey on that project to the center. But I wanted to harken back to what Judy said about an awakening, because this idea of data, the importance of data, how to use it, how to collect it, how to employ it, and how it helps us understand policy, I think is part of this awakening in the legal profession right now. And so what the center is doing is critical to that, but so is what Arizona and Utah are doing, because we're actually able to collect data on things that were until now absolutely unavailable, right? The idea that an ABS might exist in the US didn't exist until Arizona and Utah did their reforms. And I would also say as part of that awakening is also that the idea that the profession should be at least responsive to people who need legal help, to their clients and to consumers in a different kind of a way. And I think that data collection goes hand in hand with this. We're essentially talking about as a market here, right? And lawyers as suppliers of legal services have not been responsive to the demands and needs of the market. Understanding what those demands and needs are and how to meet them is a part of data collection, but it's also a part of the access to justice crisis and the sustainability for lawyers, particularly solo and GP.
My guests today are all contributors to a special issue of GPSolo, the magazine of the American Bar Association's Solo, Small Firm, and General Practice Division. And the special issue is devoted to examining the issues surrounding re-regulation and the legal profession. An effort that has gained momentum in recent years is essential to addressing a widening justice gap. You've heard a little from each of them about why they support re-regulation, but what's the evidence that re-regulation will in fact be effective in closing the justice gap? When we return, I'll put that question to the panelists. But first, let me tell you about the sponsors who make this podcast possible. Don't spend time tracking down your client's signatures for documents. The newly released e-signature feature from Practice Panther makes it easier than ever to manage time-sensitive documents in one place. Access real-time signature statuses, safely store documents, and send clients notifications without navigating to another platform. Learn more about how Practice Panther can save your law firm time at practicepanther.com/signature. Welcome back to LawNext. Before the break, we were talking about the importance of compiling and analyzing data in order to measure whether re-regulation initiatives work. Joey Gartner described an effort currently underway at the ABA Center for Innovation to compile comprehensive indices of the data that regulators should be examining. But without that data, what evidence do we have that regulatory reform measures will work, that they'll actually lead to a narrowing of the justice gap? As we return to our conversation, I pick up there with our panelists. I think that raises a really interesting question. I'm really kind of sensitive to the data issue. Just in my own experience, I'm on our state bar foundation, where we're constantly trying to evaluate the effectiveness of legal services programs that we fund. It's very hard to do that. It's very hard to figure out whether the money you're spending is achieving results. I mean, you can look at numbers and case closures and that sort of thing, but it doesn't really tell you the impact that you're having. But without that data, how do we know that the reform efforts that we're talking about here are going to be effective in enhancing access to justice? I mean, what's the evidence that all the stuff we're talking about here is really going to make a dent?
So let me take a stab at that, Bob. This is Patrick. We have a tale of a learning curve here. When I was president of the Washington State Bar, we implemented the triple LT. And we knew darn well it was going to work. We licensed dozens of triple LTs. They went out into the world and began helping people who never would have been able to get lawyers, and helped thousands of people. As time went by, however, we realized we never put in a data collection method into the creation of the triple LTs. And so down the road, when a whole new generation of leadership came to the bar, they said, this thing's not making us money. We're not making money off these triple LTs. And they killed the program. But it's because we never instituted a metric system, standards to collect how many people we'd helped, how many people we saved from going to court, how much money was put into the economy and saved from the judiciary, right, by this process. A lot of metrics that were there. And I think moving forward, we're all very cognizant that as we build these tools, as Arizona builds them and Utah builds them, as the Center for Innovation works on this thing, we realize that putting in the methods to collect the data to show its efficacy and its success is absolutely critical. And that's part of our project here, is to collect that data and set the standards by which others can measure success. And that's why this is really a critical piece. And that data is being collected, and we are starting down that road, and states are getting that information, and it will be better and better as time goes. But it starts with getting the standards and recognizing this had to be built into the tools from the very beginning.
Bob, this is Joey. Utah has recently started releasing monthly reports that actually capture some of this data. So it's the first look that we're starting to get into, are these sandbox programs effective? And I think the early results show some encouraging signs, but we're going to have to see how that plays out over the next period of time as other states venture into the sandbox and track different things. Maybe they're looking for different metrics at success. So I think it's going to be really key to evaluate those side by side as that space develops.
Yeah, and this is Zach. I was going to say something similar, and that is, your question, Bob. How do we know these things will work? I think we have to start with the understanding that we know what we're doing does not work. Not only does it not work, but we are in a crisis. I mean, if you look at the numbers, the figures in terms of access and the unmet demand, it shocks the conscience for anybody who's thinking about these things in terms of our democracy and the role that civil justice plays. So the status quo is absolutely untenable. Until we can break the status quo, though, we can't get evidence. So the sandbox is extremely important to understanding whether or not these things can work. And the sandbox actually is a very modest approach, right? Arizona was much more bolder and said, well, we know we can do this, and we're just going to go ahead and do it. The sandbox is measured, we're testing things. We're going to collect data. We're going to regulate it in real time. And if anything goes wrong, we'll put the kibosh on it. But Joey's right that we're starting to see some evidence, and the evidence that we had from other countries, I think, was enough to let us understand this critical point. The status quo is absolutely untenable in this country. The reforms that were tried in other countries may not have a direct connection to increased access to justice. That's debatable. But one thing we do know is that the sky didn't fall. The ethical standards of lawyers didn't suddenly collapse. Big corporations didn't suddenly take over all legal services. And I think that's important to understand in terms of framing this discussion.
Bob, this very conversation that you're engaged in right now is the case study for why very often, in my experience, certainly significantly so, cross-disciplinary, multidisciplinary approaches to problem solving is the way to go. I mean, what you heard is that lawyers had the solutions with regard to the legal aspects, but not necessarily solutions on how the project management should work in order to get that data collected in that first trial. So when we sit down with people on the social science side, the people who are trained in that regard, what we find is that our solutions become better and it becomes a stronger case for helping the public. Data is critical. It's critical for assessment. And I will also share that it's not the only thing that we need to do, because I believe that stories change people's minds. And that's why I contributed what I contributed about taking risk on and looking at what I needed to do for my life personally in the health arena, because I think those stories are critical. And I also think that the data is critical. And when those are combined, we will help people understand what more needs to be done to take us from whatever the right movement is away from the status quo, which is not working, to what is good for their state and their jurisdiction.
And your contribution to this issue is a story about a visit to a health professional that turns out to be a nurse practitioner, and a little trepidation maybe about that at first, but then realizing all was well.
All was well.
All was well. And I should say, obviously, none of us are launching into this without any prior research or thought into this. I mean, there's a lot of people who put a lot of thought into this. Two have been on this show, Jillian Hadfield and Rebecca Sandifer, done extensive research demonstrating the viability of a lot of these options. And so we're not operating from nowhere. Patrick, your opening to this issue was a really cleverly written hypothetical about a mega company that had the monopoly on delivering legal services and yet couldn't make its business model work, and kind of use that as a setup to say, well, we're gonna pull together the information that you need to better understand how disrupting that model can work to the betterment of not just the customers, but the business. Do you kind of view this issue as a sales job to the legal profession on why we should be doing this? I mean, it's clearly addressed to lawyers, and it's clearly making the case, I think, to some lawyers many lawyers are clearly still skeptical about this. So do you see this as trying to persuade them, to make them come around?
I think everyone needs to have the information to make solid decisions. And so this magazine is an opportunity to see the information, the data, the thought leadership, the steps that have been taken all in one place. It's a one-stop shop for this. But look, I'm a small practitioner, and we all view our business model with wanting to have success in it as a practitioner. And I think these rules of ethics, they're walls of protection, but who are they protecting? Mm-hmm. I don't think, frankly, they're protecting lawyers because I'm feeling bound by them. I can't do the things I want to do to help clients who need me. I can't get access to technology or investment, or I can't partner with people. I feel like handcuffed to be able to do my job and my duty as a lawyer to serve the public, to help the public, to get legal services to the public, and these rules are in my way. I think this magazine talks in a number of ways about how solo and small practitioners will see financial success. They have the chance to grow, to bloom, to make money. And at the same time, and this is the perfect opportunity, to bridge the access to justice gap and solve the problems that we've had. What better combination is there than to make money and thrive as lawyers, and to bridge the access to gap and give greater opportunity to those who need us? And I think that's what this opens up. And the article I wrote discusses how these walls can come down and what that might look like. Because frankly, we're the only profession that has these walls up, and we're the only ones that are handcuffed into this model. Everyone else gets to have interdisciplinary access. I mean, imagine, I use this example in the article. If pilots and lawyers were the same, and only pilots could fly, and only pilots could run the airline industry, and only pilots could create airports, can you imagine with the skill set the pilots have, whether we would have the travel industry that we have and planes built, right? It would never happen. And it's the same thing for lawyers. We need to get outside of the skills that we have as lawyers, which is being courtroom advocates, and expand and work with other professions so we can truly unleash our abilities and do the jobs we need to do.
Justice Timmer, you have in Arizona taken what Zach referred to as a very bold move in the measures you've taken. So has the sky fallen in that state?
No, not so far. I guess I'm surprised that others haven't done it. And I get it, going to the sandbox approach and such. So I guess I didn't realize we were that bold. It was unanimous with our court to proceed that way. We've had experience, though, as I say, with regulating into other entities for whatever reason that I've never been able to fathom. We also regulate defensive driving schools. We regulate juvenile detention centers, and we run the probation department in Arizona, among other entities. So we've had some practice and success and comfort level, I think, with regulating entities, and maybe that made the difference. We also had the Board of Governors for our bar on board, not unanimously, but they were on board with the recommendations. So I think that the mood in Arizona is cautiously optimistic. A number of people waiting to see, watching, but we had allowed a lot of input from the bar and lots of presentations and brought lawyers along with us and invited them to weigh in with how they think it should operate before we kind of built the system. So we haven't had the kind of pushback some other states have had, which is good. So we'll see, but we're still young at this, but I'm confident that it will be a success.
Judy, do you want to say
This is
something?
Judy. Yeah, it strikes me that if we take a moment and think about what Justice Timmer just said in terms of that experience that the court had and the state had that allowed them to move to really enhance their regulation. If everybody would just think back to the fact that we have, I think it is 14 statutorily authorized areas of federal law where someone other than a lawyer can serve as an advocate. And there is one state that has a state rule that says that someone other than a lawyer, at least one state, can serve as an advocate. We didn't necessarily collect data. No one collected data on those successes and those outcomes and those outputs. But boy, if that's not a learning for all of us to look to, there aren't lots of claims in those areas of federal statutory authorization where people were misguided by the non-lawyers who were trained up and certified and able to do the work that was needed for those in need. And so that's a wonderful set of data experience, at least, that we have, although we might not have the cold, hard data metrics that we talked about earlier. But those are success stories that we have to look to.
Right. We've talked about Arizona, Utah's sandbox, and a handful of other states in various degrees of exploring this issue. But there are a number of states that really haven't taken any action of any significant kind on this issue. Zach or Joey, I mean, you both kind of have a broad view of this. I'm wondering, are we at a tipping point on this? Is there turning back? Are we headed toward eventually this becoming the norm across the country, or is this an anomaly?
Well, Joey, I'll step in real quick. This is Zach, and I think, well, actually, Don Bivens is happy to say this, I think, and I wouldn't misrepresent him when, he said in the past that if it isn't in your state now, wait a little while. It's going to get there. It goes back to two things, I think.
And Don is the chair of the Center of Innovation for anybody.
Yes, thank you, Bob. It goes back to two things. And first, the status quo is not tenable. It really isn't, and it is degrading to the civil justice system if we allow it to go this way, and to our democracy. So that's problematic. Something will have to change in states. The second thing that I think is really important is that as other states take a leadership role in this, I point immediately to Arizona and Utah. By making this a reality, we have somewhere to look to. We have the beginnings of some data. And one thing we've learned as a research center at ISLES is that when we have data and the other side, for instance, justification for 5.4, there's almost no data supporting the connection between independent judgment and the categorical prohibitions on business activity in 5.4. Our opponents are going to have to argue with our data, but they have nothing to support their arguments. We're going to see more and more of that. Two other things are happening. Joey mentioned earlier, Utah is starting to report data, and nothing is conclusive. But by now, we know that on average, they're delivering 1,200 legal services for every one complaint by a consumer. I'd love to know if that sort of ratio is what lawyers expect. We don't know that, but I think that's an important figure that we can work with. So that's happening, and then something else is going on too. As a direct result of what Arizona and Utah did, we're starting to develop a community, a multidisciplinary community of economists, sociologists, data scientists, and they're coming together on this topic. That will only grow and strengthen and enable other states to do this better, maybe a lighter lift. So I think all of those factors come into play. And the last thing I'll say is I do think the pandemic has amplified a lot of these dynamics. So the need has been amplified, but so has the ability and the understanding of the profession to adapt and to change. And things that may have been thought absolutely impossible 2 years ago are being accomplished at record speed, at least in the context of the legal profession.
Yeah, that's really a key point. Joey, anything to add?
I think, the article that our chair, Don Bivens, and I worked on, which is, what every lawyer should know about the ABA Center for Innovation, kind of frames the question this way. There are two solutions to this problem. Either you fund LSC and assume that the access to justice gap can be solved by money and funding, or we reevaluate what we think the issue is, right? And we start thinking about it from a perspective of how can we create a sustainable practice model? How can we create a world for attorneys where you can thrive and make money and also help this 80% or so of the population that's currently left out? So I think you have to think about it from the perspective of opportunities as well as, challenges. Are we reaching a tipping point? It's near. I think, to Zach's point, the pandemic has certainly sped up the appetite. There are conversations now that didn't seem possible 2 years ago, because I think people are looking a little more forward in the practice than we used to. And I think that there's a little bit more acceptance of this as a conversation. I think there was a point in time where the idea of reregulation or regulatory change was something people didn't want to discuss. It was a non-starter.
About 2 years ago.
Yeah. And now it's a topic that, is actively engaged in. We're doing a speaker series with Isles and Legal Hackers and some others that is designed to bring this conversation to the profession. And to Patrick's point, bringing it to the 60% of small firm or GPSolo attorneys who occupy that space is pivotal in driving this conversation forward.
Yeah.
Bob, may I weigh in briefly on this? This is Anne.
Yes, please.
As far as the national spread of this, I mean, of course, you're aware that there are a number of task force in different states that are examining the same thing. I've spoken to a number of them. I think most of us in this call probably have at this point. The Conference of Chief Justices is very interested in innovation and have directed states to the courts to look at these things. I know I'm going, and maybe some of you are as well, to the Western Conference of the CCJ over Labor Day weekend to talk just about these topics. So it's something that the courts are very interested in. So I imagine it will spread. Why Utah and Arizona have kind of gone faster, I think, than other states is because it went from the top down. My impression, and I've talked to Dino Jimenez about it from Utah, that when it came from the court saying this is what we want to do, it was easier to move things along than I think than when it bubbles up from the Bar Association or another group. So that probably explains the speed.
And Bob, this is Judy. And, we cannot deny, and we shouldn't, that the lawyers, the members of the legal profession who are lawyers, are watching the fact that the courts are leading on this. To the days of having on the ABA Commission on Futures the likes of former Chief Justice Wallace Jefferson and Chief Justice Mark Martin and others who sat at the table and rolled up their sleeves to talk about these very difficult issues, to knowing when we've engaged with the Conference of Chief Justices, the National Center for State Courts, to see them leading on these issues, I will suggest to you will bring along a lot of lawyers. Because these are judges who are seeing in their courtroom each and every day, each and every week, the challenges that lawyers face and the challenges that litigants face. And this isn't only about litigation. We can't forget that. It is about transactional access to transactional services and other services as well. But critically so, lawyers are watching and listening to the fact that judges are taking a real leadership role on these issues. And that we have to appreciate, but most importantly, we have to make sure that we are standing with them.
Yeah. Well, as you say, they are really in the trenches on this issue. I mean, the courts are so hard hit by unrepresented litigants, overwhelming every aspect of what they do that I guess they get a really unique perspective on it. You know, we're talking a lot about 5.4, which is really only one part of re-regulation, and re-regulation is probably only one part of a much broader discussion about what needs to be done to address access to justice. But I mean, are there other significant parts of the re-regulation that we need to be thinking about besides just the ownership issue?
Well, this is Anne. I think other things, if all states haven't done it, is ethically allow for unbundled services, because there's a huge market out there for people that they don't want a lawyer to represent them in their entire matter, but they would really just, like a little consult on some things. That's very helpful if states haven't done it. Also, some of the solicitation and advertising rules need to probably be looked at and updated and refreshed to fit the more modern market that with technology and such. So those are just a couple things that spring to mind to me.
Mm-hmm.
Yeah, Bob, this is Zach. I would also say, and this sort of bouncing off of Judy was talking earlier about different areas of the law, at least in the federal government, where lay advocacy is allowed. So there are very promising models for lay advocacy and these exceptions to the unauthorized practice of law that are, I think, showing really great outcomes. Now, we're talking about very discrete services allowed in limited scope situations, but those sorts of services could really help huge swaths of people who are in need of service but cannot afford full service lawyers. So we're, in areas of debt collection, for instance, or in fact, I think one of the more pioneering programs coming out of Arizona with Stacey Butler at the University of Arizona, lay advocacy for domestic violence, which I should mention now. She's been involved in launching a few different similar types of services in the sandbox in Utah for medical debt collection and so forth. New York State, in its task force recommendations, kind of attached to this and said, well, we're not ready to do a sandbox, but right now what we probably could do is allow some limited licensing for social workers who know the legal challenges because they deal with it with their clients and the people they help regularly, and they can provide at least some limited advice that is far better than nothing.
Yeah, and Stacey just recently announced a relationship with forgetting the name of it, a business school at the University of Utah. Judy talked earlier about cross-disciplinary cooperation on these issues. They're working to kind of bring business expertise into the legal expertise they already have at the law school at Arizona. So that's really interesting. We just got 5 minutes or so left here, and I thought maybe do a little last round table. You could each kind of make your closing arguments here before we wrap up. So who wants to get, Patrick, you want to kick us off on that?
Sure. I think I'd just like to invite solo and small practitioners to read through this magazine and think about what this could mean to your practice. Could this help you serve more people? Could this help you make more money? And realize that these things aren't threats, they're opportunities. These things aren't protections, they're ways to open doors to greater success. And I think all of us as lawyers go to law school for the purpose of being able to help and to make the world better and to take care of the public and to be a professional and part of a meaningful profession. And I think re-examining at this stage of the game where we are and what next steps we can take to improve our profession, to improve our lives and our businesses, and to improve those of those in our community is a really important next step. And I think this article, this magazine, focuses on opportunities that are there for us to take if we're ready to take the next steps.
Yeah, and I haven't said what I'm sure is obvious to most listeners, which is you Google ABA GPSolo or GPSolo, and you'll find the website and the publication to read online or download as a PDF. So we'll encourage you to do that. Let's see, Joey, you want to go next? You're
Sure.
looking in order of my screen here.
Sure. I'm next on Hollywood Squares.
You're next, yeah.
I would agree with what Patrick said. I think that this is a really good opportunity. If this is, if you've read the magazine and this is kind of your first exposure to this topic, or sort of maybe some deep dives into the arguments of this topic, take some time and find out what's going on in your state. Look at our legal regulatory survey, but more importantly, just figure out what's going on. Is there a task force? Is there something going on? Because whether this is happening in your state or not, it's inevitably going to be something that affects the profession and affects you and affects your practice. So I encourage everyone to find out more, read more, and sort of dive into this because it's where we're going and it's, kind of the direction of the future.
Thank you, Joey. And Judy, how about you?
I think people may be surprised that even among the group we have gathered here, we may have differences of opinion about what the right solutions are, what the regulatory reforms should be and re-regulation should look like. But nonetheless, the most important thing is that we're having this conversation. And that issue of the magazine, I applaud Patrick and all the GPSolo leadership who came up with and pushed forward the idea. That is a catalyst. And what this dialogue has to be about is all of us being a catalyst for greater trust and confidence in our justice system and in our legal system. And that is going to happen when the best comes out in lawyers, which is sitting down and talking about it. And the best way you can do that, in my view, Bob, is to join the ABA and join the GPSolo division, which is free when you join the American Bar Association, and become a part of this dialogue. It's anybody. We would love to hear from you, no matter what your views are, because we know that you care as a lawyer because you became one in order to do good and to make a good living.
Thanks, Judy. Zach, how about you?
I think I have to echo what's been said here, and my dog agrees.
Wholeheartedly.
Hold on one second. Maybe we can go to someone else as I take care of this, what is probably a UPS issue.
Sure. Justice Timmer, what are your thoughts?
Well, I agree with everything my colleagues have said and don't want to repeat it. I guess I'll go for another facet of the conversation, which is to maybe assuage any fears that your listeners might have of their professional landscape changing dramatically and that could potentially harm them. Remember, we're not the first profession to go through this. The medical profession went through it 60 years ago. Doctors were up in arms at the idea of anybody but them drawing blood or practicing medicine. Now we have nurse practitioners, physician's assistants, phlebotomists, and doctors today, new graduates say, well, how could we possibly survive without them? The market changes, it develops, and that's what we're going through. So don't look at this as the world is ending. Simply look at it as it's a new world and how will you thrive in it?
Well, Zach, you trained your dog well because you get the final word.
Didn't mean to take that from Justice Timmer, but I guess what I will say is this. We started this conversation by asking, why were there all advocates in this particular issue for change? And I think the answer, one of the answers that what we might say there too, is that up until this point, really what we've heard predominantly is the opposition to this viewpoint. So having one issue where we have advocacy for change, I think is important for lawyers to be able to see it. If you're a solo practitioner or in general practice, you probably have access to the countervailing viewpoint with ease. But today, different from 2 years ago, there are many, many more resources. This magazine is an excellent place. As Patrick said, it is really, truly a one-stop shop. But there are other places too. The Redesigning Legal series, which is a collaboration between the ABA Center for Innovation and the Center for Professional Responsibility and ILS and Legal Hackers, is having programs every other month for lawyers to understand the issues, educate themselves, learn what's going on, and to hear other perspectives. And finally, I guess I'd put in a plug for ILS. We have an online knowledge center, which is also a one-stop shop. It's updated weekly with current events on what's going on in different states, direct links to state task forces and recommendations. And all of these resources weren't available 2 years ago. They are available now, and lawyers can get out there and really engage the topic. I encourage them to do so.
Well, thanks to all of you for participating today. I really appreciate it. And an extra special thanks to Patrick, who not only pulled together this issue, but helped me pull together this podcast and did a lot of work on this and suggested the idea in the first place. So I really appreciate that. And encourage all of our listeners to go out. It's a great issue. It's a great read. Congratulations on that. And thanks to all of you for all the great work you do. Stay
Thanks,
well.
Bob.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you.
I've been speaking with 5 of the contributors to a special issue of GPSolo devoted to re-regulation of legal services. You can find the full issue on the ABA website or by Googling GPSolo. Today's panelists were Judy Perry-Martinez, former president of the ABA, Ann A. Scott Timmer, Vice Chief Justice of the Arizona Supreme Court, Zach DiMiola, Director of Legal Education and the Legal Profession at the Institute for the Advancement of the American Legal System, Joey Gartner, Director and Counsel of the ABA Center for Innovation, and last, but by no means least, Patrick Pallas, owner of Pallas Law LLP in Tacoma, Washington, and the editor of the special GPSolo issue we've been talking about here. Thanks to all of the panelists for sharing their time to be with me today, and a special thanks to Patrick for helping to pull it all together. What are your thoughts on regulatory reform? Share them by tweeting us at LawNext Podcast. LawNext is produced, engineered, and edited by Populous Radio. I'm your host, Bob Ambrogi. I hope you'll join us again next time for another episode of LawNext.